Court says it's not unconstitutional. Court says, government, please legislate. Is it a setback, madam?
I think, it's just, with due respect to the honorable judges, it's just tossing the ball into another court. The prime idea is to get women their justice. There are two factors, I think, that are involved here. One is that the Quranic law is negating the triple talaq. So on what basis have the judges considered it to be constitutional at any event? The Muslim Personal Law Board has itself called it heretical, it is called it innovative, and it is called it a sinful crime. So on what basis is this law going to be sustained? That's the first thing. And the second is that, how can it be declared as constitutional when it is so anti-gender? When Article 14 says that there is equality for all citizens alike, that is men and women, how can there be this kind of a judgment? I mean, this kind of a verdict is very, very astonishing and very disappointing. I am disappointed from my heart, because from 1987, when I wrote my first book, to 1998, when I wrote my second one, I have written it with every kind of evidence to show that triple talaq is not Quranic, it is not Islamic, it was never practiced, it is never mentioned. So on what ground has this been sustained? Madam, I would like to know that.
Madam, because the news is breaking, let me also update you, because, Justice Kher is continuously reading it. So he says we will not call it unconstitutional, but madam, the practice had been stayed for 6 months. Now Justice Kher has said that I stay the practice for 6 months, but you bring in the law. I will not call it unconstitutional. You bring in the law, you do the job, you get the law in Lok Sabha and Raj Sabha. I stayed for 6 months. That's the second development which has taken place, madam.
You see, if it goes to Parliament, if
this country for practicing their religion, but further discussion can be made only after going through the entire judgment. So far as the government is concerned, I don't think that government may be required to bring any legislation, because that will be again against our fundamental right. But we make it. We will try our best, as we have undertaken before the Supreme Court, that we will try to carry on our reform program throughout the community, and to ensure that this practice of triple divorce in one sitting without any lawful justification may come to an end, or at least is reduced to the nominal extent, so that there may not be any demand for its abolition or for bringing any legislation. जहाँ तक सुप्रीम कोर्ट के जजमेंट का ताल्लुक़ है कि उसने इसको अल्ट्रा वायरस डिक्लेयर नहीं किया, हम उसको रेस्पेक्ट करते हैं और हम उम्मीद करते हैं कि इससे जो फंडामेंटल राइट्स हैं उनको मज़ीद तक़वियत मिलेगी और देश में सेकुलरिज्म और रूल ऑफ लॉ और रेस्पेक्ट फॉर द जुडिशरी इस पर और इजाफा होगा और ये देश डेमोक्रेसी इससे स्ट्रेंथन होगी। और जहाँ तक कि इस प्रैक्टिस का ताल्लुक़ है कि ये 3 तलाक़ एक वक्त में बग़ैर किसी लीगल जस्टिफिकेशन के देना, इसको कर्ब करने के लिए और ख़त्म करने के लिए हम बहुत ही हेक्टिक एफर्ट्स करेंगे। और पर्सनल लॉ बोर्ड की सिलसिले में मीटिंग भी वर्किंग कमेटी कन्वीन कर ली गई है जजमेंट को स्टडी करने के लिए 10 सितंबर को, और 10 सितंबर की मीटिंग के बाद हम मज़ीद डिटेल्स उस पर देंगे। लेकिन ये अश्योरेंस जो हमने सुप्रीम कोर्ट को दिया कि हम इसमें इसको प्रैक्टिस को ख़त्म करने के लिए ये भी एफर्ट अडॉप्ट कर सकते हैं कि जो काजी हैं उनसे नकाह पढ़ाने वाले उनसे कहें कि वो हस्बैंड और वाइफ दोनों जो ब्राइड और ब्राइड ग्रूम को ये बात बताएं कि 3 तलाक़ एक वक्त में देना ये बहुत ही बड़ा गुनाह है, और इसलिए अगर वो चाहे तो ये निकाहनामे में इसको रखा जा सकता है कि वो 3 तलाक़ एक वक्त में बगैर किसी कंपलिंग रीज़न के या बगैर वाइफ की डिमांड के नहीं दी जाएगी। इस टाइप की बात निकाहनामे में लाने के बारे में हम सुप्रीम कोर्ट से कह भी चुके हैं और इसको हम कैरी ऑन करेंगे। और बोर्ड की मीटिंग जो हो रही है 10 सितंबर को, उसमें इस सिलसिले में मजीद स्ट्रेटजी तय करेंगे।
कहाँ पे की जाएगी सर?
ये मीटिंग भोपाल में हो रही है।
भोपाल में होगी 10 सितंबर।
So, you know, the bottom line here is that the government will need to bring in the legislation by 2018 budget session. There is a winter session, the monsoon session is over, the winter session takes place between 1st of December to 15th of December, which means that the next budget session, which has been preponed by the government of India to 1st of Feb, which used to take place in March, which means the window will end on 15th of February for Narendra Modi's government to bring in a legislation, which also means that he will have to get it passed in the both houses. So we will have to show what are the numbers of BJP members in Rajya Sabha, what will be the numbers in Rajya Sabha in 2018 budget session of the parliament. Will the assembly elections which have taken place in the state make any difference? And we will be showing you the graphic. And we'll be showing you the graphic with detail as to what difference will it make. I'm joined by my colleague Raghvendra Rao. Raghvendra, your first take on the decision which is breaking from the courts.
Well, yes, from whatever we are hearing from inside the Supreme Court, it is that the Supreme Court has asked the government to frame a new Muslim divorce law within 6 months. Now, you know, only the Chief Justice of India, Justice Keher, has read out his portion of the judgment. The other 4 judges are yet to, read out their portions, respective portions of this judgment. But yes, this sounds very major because Chief Justice of India saying or asking the government to frame a new Muslim divorce law, and that too giving a timeline or a deadline of 6 months, is a very, very significant development as far as this entire, this entire matter goes.
Raghvendra, yes, Raghvendra, but is the judgment still being read? Is the order still being read? Because there are parts of...
Karthikeya, yeah, because this is what we are hearing as of now is only the portion which Chief Justice of India, Justice Keher, has read out. The remaining entire, judgment and whatever the other 4 judges have to say on the matter, it is still under process. So the full contents of the judgment are still not out. We may get to hear more inputs coming in just a while from now.
And I'm also, Raghvendra, you stay with me. I'm also joined by Sharad Gupta, political commentator, senior journalist. Your first comments on Supreme Court saying, we will not call it unconstitutional one.
Right.
We stay it for 6 months, government legislates. So my question to you, sir, is, Supreme Court can run cricket of this country. Supreme Court can make laws on roads. Supreme Court can make laws on NGOs, but Supreme Court cannot make laws from the gender perspective, gender justice. I'll also correct myself, gender justice.
Yeah, I feel the justice has not been done. The court has actually not taken the step it should have taken. It needed to define the constitution and let down a clear verdict. This verdict is basically obfuscating. Yeah. So this is not a clear justice, not a clear verdict. So I'll say the Supreme Court has not taken the step it should have taken. That's my take.
Madam, you?
I think it's going to throw up a very ugly situation. And there are 2 aspects to it. First is the Muslim patriarchy. Are they going to rise above political issues and other issues and show that they can take the leadership on this? The onus is on them. The second is it going to show that political parties are again using gender as cannon fodder in their fight for political power? Or are they going to show that they want political power for common good? And what is the purpose and nature of political power? So this is going to get ugly. And we have to show the nature of our democracy. Are we going to going forward? Are we progressive? Or is our political system really entrenched in vested interests? And therefore we are using gender justice as just another, as I said, cannon fodder situation.
You had actually hit upon this point even before the judgment came.
Yeah.
So my second question is also to you. Will it be really possible, the sort of distribution of representation of political parties in Rajya Sabha, will it be really possible to meander this law? Because I had seen the way Women Reservation Bill was passed in Parliament in Rajya Sabha. That was unprecedented in my limited time of reportage of Parliament. Will they have enough numbers, and wouldn't it provoke a debate which can actually border on majoritarianism versus minoritism, you know, completely taking a different tangent, madam?
That's what I told you at the beginning, that this is a challenge to women cutting across all communities as well as political spectrum. Are we together in this fight for gender justice, and we can cock a snook at political parties and say, we want this, you better support us come what may, or you will see the result in the next election. This is the challenge. we are thrown the gauntlet, so to speak. Unless women's groups across, as I said, cutting across the nation, collectively voice it the way we did Women's Reservation Bill, the political parties will have a heyday making cannon fodder out of us. It is also an occasion for the Prime Minister to really show that he can rise above the narrow spectrum of his limited agenda and bring other political parties with him to carry this forward. Does he have that kind of nationalistic outlook that we saw in Nehru, where he could bring people together? And it is a test for the Prime Minister today to see whether he can make this a non-sectarian issue, but a gender justice issue.
But sir, coming to you, now it completely metamorphoses itself into a political controversy? Will it cross that step? You know, there was... And sir, I'll come to you. I'm joined by Manish Tiwari on phone line.
But
okay,
the initial reports which are coming in suggest that the Supreme Court obviously thought that Article 25 of the Constitution of India gives everybody the right to practice, preach and propagate religion according to their faith and conscience. And obviously they have felt that certain religious practices which may be intrinsic to a particular faith are otherwise reprehensible. Their reform either lies within the domain of the community or it lies with Parliament. If you recall, Parliament through the Constitution of India abolished untouchability right at the inception of the Constitution. At that point in time, somebody could have argued that untouchability was intrinsic to the Hindu faith. So therefore, the Supreme Court has really entrusted it to Parliament and to the community in their wisdom to see as to how they would deal with this particular issue.
But it's not clear whether it's a split verdict or it's a unanimous.
So, you know, let me just sum it up before I come to the guests. To sum up, 3 judges have given ruling that triple talaq is unconstitutional. SC stays practice of triple talaq for 6 months. Asked Centre to bring law. Chief Justice has given his ruling. Other judges in process of giving ruling, which means it's a 5-member bench, sir.
Yeah.
So the 3 have already said that now it depends on what other 2 have to say. Because it's been that individual judges right. are coming out with ruling. So my question to you, sir, does it become a political football?
It's likely to be, because there are parties who in the zeal for getting the minority votes, they might make it a political football. They are likely to oppose it. There is a section of political spectrum which is likely to appease a section of minorities by opposing this verdict, by opposing the government's move to legislate also. So of course, there are going to be political views, but the government has already made its point clear by saying in the court that it's opposed to triple talaq. So the government is very clear about its views, but there are other parties, especially the Muslim League and such parties. They are going to make an issue out of it.
So are you saying that it will have an electoral ramification?
Of course. Let's see what Congress says. We were just about to join the Congress spokesperson. So let's see what he says.
But Mr. Gupta, Congress has taken a position. Congress, Salman and Kapil Sibal had gone there, and I had been quoting that Mr. Sibal had said that it cannot be subjected to the constitutional morality, and a lot of my esteemed colleagues and the guests in the studio had their own views on the matter, but now it seems that Madam, the court has actually concurred with that position.
Well, I wish it was an all-woman bench. First of all, these men who talk about let the legislation take its course are not the women who are at the receiving end of gender injustice. First of all, how many women were on that bench? That is the first question I would like to ask. The second question, when you say, will it become a media football or a political football, that is for us to exercise restraint and understanding, and also for the women's groups to say we will not become cannon fodder for this electoral process. We as a group, just as we stood for reservation, we are going to stand for gender justice and the abolition of triple talaq. I'm really offended by the fact that we should already decide that this is going to become a political football. No. If the BJP in power can control its Gaur Rakshaks and convince the minority community that it is for the betterment of the community and not a political gambit, I'm sure we can reach consensus. But that perception persists that it is a political gambit.
Madam, I would like you to hold your thought for a minute. Let's cut across. Lawyers are speaking. Let's cut across.
नहीं, हमेशा के लिए चीफ जस्टिस साहब का एक माइनॉरिटी ओपिनियन है जिससे जस्टिस नजीर को इत्तेफाक है. उसमें उन्होंने यह कहा कि ट्रिपल तलाक अनकॉन्स्टिट्यूशनल नहीं है क्योंकि आर्टिकल 25 ये एक एसेंशियल इस्लामिक प्रैक्टिस है और एसेंशियल रिलीजियस प्रैक्टिसेस को आर्टिकल 25 का प्रोटेक्शन मिला हुआ, इसलिए अन इस्लामिक नहीं है.
So now the Supreme Court suspends triple talaq for 6 months, asked Parliament to legislate on it. But what it does is that it is not calling triple talaq unconstitutional. Now let us go across to the Supreme Court where lawyers are giving back.
के तहत उन्होंने इस्लामिक प्रिंसिपल्स को पे आधारित ये बात कही है कि ट्रिपल तलाक जो है वो बिल्कुल गैर इस्लामी है, गैर कुरानी है और क्योंकि वो आर्बिट्रेरी है इसलिए ट्रिपल तलाक इलीगल है और उसको आज की तारीख से ही सेट असाइड किया गया.
लेकिन क्या ट्रिपल तलाक अनकॉन्स्टिट्यूशनल है? ये मेजोरिटी
ये फैसला कम से कम 2 जजेस ने तो ये बिल्कुल साफ बात लिखी है कि अनकॉन्स्टिट्यूशनल है. जस्टिस कुरियन मैंने एक मिनट बात सुन लीजिए पूरी. जस्टिस कुरियन जोसेफ ने अब जो फैसला अभी सुनाया है उसमें उन्होंने सिर्फ ये लिखा है कि हाँ इट इज आर्बिट्रेरी एंड इट इज सेट असाइड. लेकिन अगर आर्बिट्रेरी और सेट असाइड है जाहिर है कि अनकॉन्स्टिट्यूशनल के बेसिस पर ही किया होगा उन्होंने वो भी सेट असाइड. तो 3 जजेस ने आप मान लीजिए कि उसको अनकॉन्स्टिट्यूशनल डिक्लेयर किया है और सेट असाइड किया है.
अगर 6 महीने के अंदर कोई कानून सरकार बना के नहीं लाती है तो आज के फैसले के
6 महीने के अंदर जो कानून बनाने की बात है वो माइनॉरिटी जजमेंट में है, उसका कोई मतलब नहीं है आज की तारीख में.
एक बात और जरा बताइए जी, क्या जो कहा गया है कोर्ट के फैसले में कि सरकार कानून बनाए 6 महीने में, ये सरकार को निर्देश है या कहा है?
नहीं साहब, सरकार को निर्देश है कि आप एक जो है कार्रवाई शुरू कीजिए कानून बनाने के लिए. उसके साथ ये कहा है कि अगर आज ये कार्रवाई शुरू हो जाती है और उस कानून के ड्राफ्ट में ये होता है कि ट्रिपल तलाक जो है उसको आप खत्म करना चाह रहे हैं, तब तो जब तक वो कानून पास नहीं हो जाता तब तक वो इंजंक्शन चलेगा. लेकिन अगर उसके ड्राफ्ट में ये होता है कि ट्रिपल तलाक को अपहोल्ड किया जाए तो बस उसी वक्त वो इंजंक्शन खत्म हो जाएगा. लेकिन ये सारी बातें बेमायने इसलिए हैं क्योंकि ये माइनॉरिटी जजमेंट है, इसका कोई इफेक्ट नहीं होगा. मेजॉरिटी जजमेंट विल रूल. द जजेस जजमेंट ऑफ द 3 जजेस जिसके बेसिस पे फाइनल ऑर्डर आया है. फाइनल ऑर्डर.
I'm also joined by former Additional Solicitor General Indra Jaisingh, Senior Advocate of the Supreme Court. She joins me on phone line. Madam, your first take on the judgment which has been delivered on triple talaq by the Supreme Court, ma'am.
Judgment because they have held that it's unconstitutional. And let me tell you, the minority judgment is of no use to anybody. It binds no one. And so it is the individual opinion of the individual judges who wrote it. It's not the law of the land. So please don't have any confusion on this. The judgment is the triple talaq is unconstitutional. It is not just un-Islamic, but the Constitution of India will not allow triple talaq.
So, but the larger issue which is getting debated is that why is triple talaq or the whole idea of triple talaq to be done away with being sent to the legislature, to the Rajya Sabha, Lok Sabha?
As I told you, it is a minority opinion. It has nothing to do with us. The law declared by the Supreme Court is that triple talaq is unconstitutional. Now, it is up to the government to decide what they want to do. No one can stop them from passing a law. No one can compel them to pass the law. It's their choice.
So you're basically saying that the 3 judges out of 5 have said that triple talaq is unconstitutional. So it is...
Yes, yes, and 3 is the law. The minority binds no one.
Oh, so basically from today onwards, triple talaq has become unconstitutional because, you know...
Yes, from
because
this moment onwards.
Yes.
From this moment onwards.
So it is... Okay. So which means that it is a major victory for women?
Yes, a very big one.
Very big
All
one.
women. And I was going to tell you, not just Muslim women, Hindu, Muslim.
I didn't use the word Muslim, madam.
Everybody. Because once you declare it unconstitutional, the constitution only will govern all women.
So basically, it's a judgment of 3-2. Indraji, it's a 3-2 judgment where triple talaq is unconstitutional. So that's loud and clear.
Yes, totally clear. Please don't confuse your listeners.
No, not at all. Thank you so much. So good news finally coming in. 3 judges have said, bit of a confusion, part of TV reporting, so I apologize for, number of contradictory messages which emanated from the court. Let me go across to Jessica Taneja. She was in the courtroom listening to Justice Kehar. Jessica, tell us what happened. You were there.
Well, Kartika, you're absolutely right. There was misreporting, in fact, on this matter. One had to wait inside in the main court to understand what the judgment was going out to be. I think hurrying up sort of does not solve the problem. What we do know is it has been declared unconstitutional after all. As suspected, as predicted, it is unconstitutional. The bench ruled 3-2 in favor. So even as you heard, I was there, Justice Kurian, after Justice Kehar finished, Justice Joseph Kurian said that he opposes, I'm quoting him, he said he opposes the verdict given out by Chief Justice. He says, no, we do not need 6 months to legislate this. It is unconstitutional. Triple talaq is unconstitutional. It does not find itself as a holy sanctity in the religion. The freedom to religion cannot take away people's rights. And this is right to freedom. We need to give people the right they deserve. So this is where he disagreed, and so did Justice Nariman, who concluded after him. He said that we are both in agreement that triple talaq needs to be declared unconstitutional.
So, Jessica, we can say that the triple talaq has been declared unconstitutional. It does not. But then, why did it say that it stays for 6 months? Can you please explain that portion?
Pardon me, Kartik, I couldn't hear the last bit.
Can you please explain me then why did the court say that it is... why did the court say that, we stay triple talaq for 6 months and then, there should be a new law?
See, Kartik, what actually happened inside the Apex Court is when people, rushed in to bring out misinformation or half-cooked information. It was after the Chief Justice of India who concluded by saying that we need to give it time, we need to give it 6 months for it to be legislated. Until then, talaq-e-biddat or triple talaq will be kept on hold, will be a void practice. But what followed next was something that we did not expect. Perhaps we preempted that this particular modern era would get rid of archaic practices like these. And then came the announcement. Then the judges finally started individually reading out their particular judgments. And that is where we got to know that this is actually in favor of unconstitutionalizing triple talaq rather than favoring the practice of making it legislative for putting in for legislature for 6 months. But at the same time, this is what the court came out with. So ultimately, that is where the misreporting of facts came in. Because if you go by the Indian Constitution and the Indian law, it has to be the majority, that's not the minority. Even a Chief Justice of India has ruled in favor of a particular, the case of making it constitutional. It would have been not in his favor. The judgment will still prevail with the majority that decides that yes, it is unconstitutional.
So basically, Supreme Court has invalidated triple talaq. That's the bottom line.
Absolutely, Kartikeya. They have invalidated triple talaq. This is a big judgment. Although you see, it was only Justice Abdul Nazir and Chief Justice of India, Justice Kehar, who had given the judgment saying that their judgment was separate. Both of them combined their judgment, saying that right now we cannot declare it unconstitutional. It has to be tested in the legislature for 6 months.
I think you made a very important point. You are basically saying, Jessica, you are basically saying Justice Nariman, Justice Lalit, Justice Kurian, they said triple talaq is unconstitutional. Justice Nazir and Chief Justice of India, Kehar, said that, it is constitutional. So that is how it became 3-2.
Well, Karthikeyan, not exactly saying it's constitutional. Pardon me for the hastiness here. They said that we need to test it for 6 months in the legislature, thereby actually clearly not saying it's unconstitutional, but at the same time, of course, not saying that it's constitutional as well. One will have to take their own extract our own meanings out of it. But if we stick to the legalities of it, they of course enforce the fact that they didn't seem to be opposing triple talaq. They said that we need to keep in mind the religious freedom of individuals as well. So I think they've both kept in mind that particular argument made by the All India Muslim Personal Law Board. But looking at the 3 judges, remember Karthikeyan, this is a 5-judge bench comprising of the judges from different religions. And it is quite astonishing to see that a Christian judge, Joseph Kurian, a Parsi judge, Justice Nariman, and of course, Mr. UU Lalit siding with each other and coming out with a judgment that finally helped these women gain freedom from the tassels of triple talaq, which have been devastating them for years.
Jessica, you stay with me. I am also joined by my Syrian Foreign Affairs editor, Padma Rao Sundarji. Padma, coming straight to you. Can we safely say it's a victory is it a victory for women? I'll go, I'll cut across to Padma Rao Sundarji in a short while. She has joined me from newsroom. I'll patiently wait for her. Meanwhile, now Padma, can you hear me? Now Padma can hear me. So Padma, is it a victory for all or for women in India? This judgment redefines the debate in terms of reforms for various communities, within various communities, when it comes to women.
Well, as a woman myself, I would certainly see it as a victory. But let me point out, it's a victory for the judiciary of India, I would say, because the judiciary of India is actually following the right, the avenues, so to speak. It is pointing it is passing, the matter back to the legislature. Ultimately, whatever is in the constitution, and whether 3 out of 5 judges deem something unconstitutional or not, whether the centre deems it unconstitutional or not, the fact that there are personal laws in India is a matter that is a contentious matter, as you know, Karthikeyan, for very long. Now, to amend or to make any changes to the constitution, or perhaps even to remove the vagueness in the constitution on the personal law boards and to introduce an element of certainty, or to abolish the personal law boards altogether, whatever the amendments may be to the constitution, it is the legislature and not the judiciary. And the Supreme Court has said this repeatedly, and in many matters where petitions have been directed to it or come to it directly in matters pertaining to constitutional amendments or constitutional readings or constitutional refinements even, it has pointed the finger back to the legislature, and that is the way it should be. So I think we have reason enough to be proud of the fact that the judiciary is following the right steps, and is also, there is a requiem of 6 months which it is imposed, and in that sense, this is, as we say, following the right avenues and going through the right channels, so to speak.
A lot of people are saying, Padma, that generally this whole debate on triple talaq is not being viewed from the perspective of gender justice. It gets viewed as a political masterstroke. It gets viewed as something which should have been done but couldn't be done because of a political party, for vote banks. Do you think that that gender justice position has been restored?
Well, it's difficult to say that, Karthikeyan. I'm always cautious about, there's no one gender justice, there's no one, 99.9% of India's women may agree that triple talaq is unconstitutional and unfair to women. Maybe there is that 0.1%. I mean, we are in a democracy, and I think even those who have opposed the existence of personal law boards are very conscious of the fact, and that is why, in fact, matters have, reached the Supreme Court at all, because there is a judiciary in place, there's a House of Justice in place. We're not a banana republic, so all sides have to be listened to, and the Supreme Court has, studied all aspects, has given its opinion. 3 out of 5 judges had a different opinion. They see it directly as unconstitutional. That is their reading of the Constitution. The other 2 judges have simply said, have put a kind of a stop on it for 6 months and handed. Essentially, the Supreme Court, the judiciary, cannot decide on matters matters that pertain to the Constitution of India. If it needs to be amended, if it needs to be refined, if it needs to be rewritten even, it has to go back to the people, which is the legislature. And that is what the Supreme Court has pointed out today. I would certainly see it as a victory for all the women who are against the triple talaq. But then again, there might be a 0.5% of women who, for whatever obscure reason, may be in favor of keeping those personal laws in place. Either ways, it has to go back to the people, the people's representatives, and in that sense, the Supreme Court has done the right thing.
Okay. Padma, you please stay with me, and so do you, Mr. Gupta. Let's cut across to the former Minority Affairs Minister, who is addressing the press from Bangalore.
The Muslim law is very clear. The Muslim law has never has justified an instant 3 talaq. It is misuse of certain provisions. Now, with the Supreme Court judgment staying the triple talaq for 6 months and asking the Parliament to enact law in accordance with the Muslim law, I am confident that the Parliament, in its wisdom, will prepare a law in accordance with the Muslim law, which is what is stated in Quran and Hadith, not on the traditions. And the Supreme Court, the Chief Justice has also cautioned that netas should keep their personal view aside while making judgment. I hope this is a direction, though it is not a direction, but what has been observed by the Chief Justice is very relevant, because no personal or any party's view should not come. It should be in accordance with the Muslim law and not in any other views of any individual organization or individual party or a political party. That should be kept in view while making the law.
Sir, but there are different views by the justices.
Yes, it is obvious that Article 25 is a fundamental right, and then we have different judgments even earlier also, because it is a very sacred right under Article 25. Nothing should be tinkered to interfere in the religious rights of any individual. So, keeping that spirit, the two judges have said that you cannot say it is unconstitutional and reforms is necessary, and then if we go on interfere, we should allow the society to reform, and we cannot interfere in this matter.
So, the former Minority Affairs Minister saying that he supports it. He was Minister between 2009 2014, held the portfolio of Minority Affairs, currently member of Lok Sabha,